All right, 5 of the most common myths that I run into in post-conviction work. Number 1 is that just because you pled guilty does not mean you cannot appeal. You waive a lot of your rights to appeal, but if there is something on the record that reflects ineffective assistance of counsel, that is still something that you can appeal. Number 2, all hope is lost if you miss the deadline. That's not true. There is equitable tolling. There can be arguments that can be made that you could file something after the deadline. Those are often hard to win and they're relatively narrow, but just because you miss a deadline does not mean that there's not any way to fix it. Number 3, I have an open and shut case, so this should move quickly. That is almost always not true. Even if you have clear DNA evidence, sometimes it can still take months or a year or longer before you can actually get the relief you're seeking. It doesn't necessarily make sense. The best way I can explain it is the wheels of justice turn slowly, and even if you have the proof that you need, it doesn't mean that you're going to get the court to agree that the proof results in the immediate release or remedy that you're seeking. Number 4, what matters most is that I'm innocent of the crime. Sadly, that's not true in post-conviction or criminal law in general. What's true is that it matters what you can prove. So at the end of the day, whether you're innocent or not, sadly doesn't really matter. What matters is if you're innocent, can you prove it? Or whatever the case is that you're trying to make for your post-conviction relief, that you can prove the case you're trying to make more than the fact that you feel that way or that it is frankly factually true. Just because it's true isn't the main question. The main question is, can you prove it? And fifthly and finally, one of the biggest things that I run into is my attorney made a big mistake, an obvious mistake, and that entitles me to relief. Sadly, that's not true. Under what's called the Strickland standard, even if your attorney made an objectively unreasonable decision, it is just clear that the attorney screwed up, that still doesn't matter if their screw up did not determine in the mind of the judge the outcome of the case. It still has to prejudice the outcome. So even if there's a big screw up on the record or a big screw up in some way that you can prove from your attorney, you then have to prove that that screw up was bad enough that it determined the outcome of the case.